balanced view on politics in today's world. Based on facts, born of rationality, common sense, and logic. Providing context on today's events, this is American Perspective with Rick Thomas.
Hello, everyone, and welcome to American Perspective. And I am your host, Rick. Just got to say, this is my favorite Halloween background. I love this thing. It is so, I mean, for those of you on the audio portion of the program, you've got to check it out. You got to come over to rumble.com and check it out. But just to give you a description, it is a blue owl with yellow eyes, and it's zoomed in to the point where the two yellow eyes are like right above and on each side of my head. It's just fantastic. It's my all-time favorite. I gotta say, I love this thing. I've been holding it back, but I decided to go ahead and use it tonight. Anyway, so just, well, I hope everybody's weekend today, Saturday, the weekend. Yeah, and you know what's even funnier is I don't even know where I got it. I can't remember where I got it. I don't know if it was one of Buddy's submissions from a long time ago. I'm not even entirely sure, but anyway. Also too, Bam, our resident cook. See, Bam over on Rumble, she usually is cooking and watching the show at the same time. And so she'll come in and she'll tell us what she's cooking. And, yeah, let's just say that there are times where she says something and then my mouth ends up watering and I'm like useless for the rest of the show. Anyway. All right. Someday, folks, I'll get out to all of you. Except for maybe Becky over on Australia. Although I would love to go to Australia. That would be awesome. That would be awesome. And I guess Coco DeWhiskey is also cooking as well. So yeah, there we go. You guys will fatten me up quick. All right, let's go ahead and get things started. Tonight is definitely not Karen in the Pledge of Allegiance for tonight. So please, if you would please stand, remove your hat if you're wearing one. And if not, even if you are wearing one, I mean, take the hat and put it over your heart anyway, but place your hand over your heart and let's follow along with Definitely Not Karen in reciting the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Definitely Not Karen for that. I know DNK doesn't show up early. Usually he comes in and pops in a little bit later, but thank you for that rendition. And Becky is cooking breakfast right now for those of you who are of the foodie kind. Hey, don't forget the food stuff is coming up. Remember, for Thanksgiving, and I got to talk to Kirk. I should reach out to him. But I got to talk to Kirk. We usually do the Thanksgiving special where he and I discuss recipes and things like that. So anyway, we'll have to, I'll have to talk to him and get that scheduled, get that on the books. In terms of upcoming. And then of course we also do a Christmas, gift special. So I got to talk to him and get that one on the books too, for the show. So, anyway, no, it's not, storybook night. Yes, it is. It is. All right. So we've got, we've done the Pledge of Allegiance. I am so far off the tracks here, folks. I mean, we just going off the rails here, all because of Bam and her cooking and then Coco DeWhiskey and her cooking. I told you, I get off the track here. All right. Well, let's get on with the tonight's promo. Headline promo. Institute on the Constitution. The Institute on the Constitution was established in 2004 as a 501c3 nonprofit with one singular mission, and that is to restore the constitutional republic through grassroots education. All courses and materials are developed using primary source documents and taught from the American view of law and government as defined in the Declaration of Independence and the following 3 key points. 1, there is a God. 2, our rights come from him. And 3, the purpose of civil government is to secure and protect our God-given rights. The IOTC offers the opportunity to educate yourself on our most precious founding document, the Constitution of the United States. They also provide tools to educate your community and get involved with local government. Start by taking their free U.S. Constitution course and go from there. Use my affiliate link, iotc.americanperspective.online, to sign up. And while you are there, to take a moment to look through their other course material and information. My affiliate link, once again, is iotc.americanperspective.online to get great content to learn about our historical founding and support the show in the process. That's iotc.americanperspective.online. Or if you just want to purchase this fabulous Saddleback leather-bound U.S. Constitution to support the show, go to constitution.americanperspective.online. Check this out. It's got 1/8 of an inch of Saddleback leather. Its pages are tear and water resistant, and they don't cheap on the binding here. This is not some cheap glue holding this together. They stitched it all the way through the leather and the pages within. It has got a 100-year warranty against materials and manufacturing defects, such that they will either fix it or replace it for free if you return it to the manufacturer at any time during that 100 years. My rumblers are favored in saying that it has sexy rounded corners, which keep you from poking yourself in either your rear end or the chest, depending upon where you want to put this pocket-sized U.S. Constitution. This is really a true keepsake. You should think about this for Christmas. Christmas is coming up. It fits into a stocking quite well. And you can give it to everybody. I mean, the liberals, leftists, and your family and friends will probably be pissed off, but all of the conservatives will love it and hang on to it for a very long time. Go to constitution.americanperspective.online and get yours today. Oh, I forgot to say, this is buddy tested, buddy approved, Billy tasted, Billy approved, and my youngest whiskey warrior has proven that the contents contained within are true and actual enough to get you your civics badge in Scouts. Go to constitution.americanperspective.online and get yours today. And of course, check out the rest of the Institute on the Constitution as well. I do appreciate them for allowing me to be an affiliate. All right, let's get things going with the first segment, fan favorite segment of the evening, which is On This Day in American History. And of course, for On This Day in American History, we read from the American Patriots Almanac, written by William J. Bennett and John T.E. Cribb. It is chock full. Look at how thick that is. It's chock full of all kinds of information and factoids about our historical country and founding that we call home. And tonight, for October 19th, had to check the date just to make sure I was right here. For October 19th, we are going to talk about the world turned upside down. At 2 p.m. on October 19th, 1781, British soldiers filed out of their trenches at Yorktown, Virginia, laid down their arms, and surrendered their flags. At that moment, the American Revolution effectively ended. British General Charles Cornwallis had taken his troops to Yorktown on the Chesapeake Bay because Southern patriots had worn down his army. He hoped to meet up with the British Navy, which might either resupply his exhausted force or carry it away. But American and French troops laid siege to Cornwallis's lines, pounding them with cannon fire, and a French fleet cut off the escape by sea. The British found themselves trapped. Thomas Nelson, governor of Virginia and a signer of the Declaration of Independence, was with the American army at Yorktown. According to tradition, he directed an artilleryman to fire at a stately brick home. "It is my home," he explained, "the best one in town, and there you will almost certain to find Lord Cornwallis and the British headquarters." According to legend, the first cannonball sailed through a window and landed on a table where several British officers had just sat to dine. On October 19th, as the Redcoats marched forward to surrender, they could not help but notice how poorly dressed and equipped George Washington's troops were. Few actually had uniforms. Many wore rags and went barefooted. Out of this rabble had risen a people who defy kings, one of King George's soldiers observed. Bands played as the British troops filed between the French and American soldiers. The Americans played Yankee Doodle. The British played a tune called "The World Turned Upside Down." After Yorktown, the British realized there was no point in fighting the upstart colonists any longer. Americans had won their freedom. And that is tonight's On This Day in American History. An incredible story and an incredible event. I mean, there was no way the largest and most formidable army of the time, the British Army and the British Navy, there was absolutely no way that the Americans had a chance in hell in winning against them. But yet, here it is. They did it. And we, as in the America, was born. You know what? I just realized I forgot to do something, so let me go ahead and handle it now. I forgot to tell you what I'm drinking tonight. Tonight is Easy Rider, which is a Kentucky straight bourbon whiskey. It's only been aged 4 years, though, versus the 10 of my other one. And it's an 80 proof, so it's a little lighter in alcohol than some of the others. But I'm drinking it out of the Lucky Shot USA We the People glass. That is, Lucky Shot USA is the maker of the glass for those. And yes, as 3 Chevy says, it takes stones to drink with me because I have stones in the bottom of the glass. Ooh. Mark has to take a call. He's not happy. Anyway. All right. So, one of the things that is kind of interesting, of course, that's going on in today's world, and trust me, I'm going to get to the whole constitutionality of regulatory agencies here in just a little bit. That actually came from an article that was published by a gentleman who I'll name later. And it's a fascinating little article, and he writes a lot of these articles for many papers. But he's just a wonderful constitutional scholar, and he keeps telling everyone, he's like, the Constitution everybody can read. You can read it in about 20 minutes. And that is so true. Speaking of constitutionality and, the government and whether or not the government's going to do anything, Daily Caller, I know this is a bad segue, but I got to get there somehow. The Daily Caller has an exclusive. The FCC commissioner is actually now seeking an investigation into the allegation that CBS distorted Harris's 60 Minutes interview. Yeah, somebody's actually calling for this. Now, keep in mind, okay, and you'll recall the 60 Minutes interview, they aired a snippet of it and then changed the answer for the actual final airing on 60 Minutes. And a member of the Federal Communications Commission has now asked the body's chair to take up a complaint that was filed with the FCC, and ultimately compelling CBS to release the full transcript from the 60 Minutes interview, which, of course, you know, Trump is already asking for that. So yeah. CBS aired two different broadcasts with the two separate answers from Harris in response to the same question on regarding Israel's Prime Minister Benjamin Netanyahu, whether or not he is listening to the Biden-Harris administration. FCC Commissioner Nathan Symington told the Daily Caller News Foundation that while the commission often receives frivolous complaints alleging news distortion, the complaint lodged, and it was lodged 3 days ago on the 16th, by the Center for American Rights against WCBS, which is CBS's New York subsidiary, is substantively different and should not be dismissed at its face value. Well, that's interesting. So we know the two answers. I played the video clip not too long ago with regards to it, and we know that it was changed. But Symington wrote in a statement to the Daily Caller News Foundation that the FCC does not regulate or even really respond to allegations of politically unfavorable coverage or legitimate editorial discretion. However, the recent complaint regarding WCBS TV raises a fully different set of issues regarding whether or not coverage was intentionally distorted, reporting that something was said in response to a question that literally was not. I don't know whether that's true, but it's a different issue. Person familiar with the FCC told the Daily Caller News Foundation that while Carr's complaint could potentially move forward, the Democratic chair of the commission, Jessica Rosenworcel, is unlikely to act on the complaint, especially 18 days before the presidential election, as we are sitting right now. We are under 20. In the event that former President Donald Trump returns to the White House, however, the commission could be given a green light to act on the complaint with a Republican commissioner appointed as chair. That same person told the DNCF. So, here's the thing. What they could do, and this is in the piece, but what they could do is the next time any of the CBS News wholly owned and operated broadcast subsidiaries attempt to renew their license under a majority Republican FCC commission, that same commission could put conditions on the license, including compelling the broadcaster to release the 60 Minutes transcript, according to the person. Now, the Carr complaint alleges that because WCBS aired two distinct broadcasts of the Harris interview, one that was on Face the Nation, and the other being actually on 60 Minutes, with different responses from the Democratic candidate, the conflicting answers amount to deliberate news distortion. The Carr complaint states CBS crosses a line when its production reaches the point of so transforming an interviewee's answer that it is a fundamentally different answer. This CBS may not do. Here, CBS has taken a single question and transformed Harris's answers such the general public no longer has any confidence as to what the vice president actually said in response to the query. Daniel Sir, who is the Carr president, wrote in a statement to the Daily Caller News Foundation, "This isn't just about one interview or one network. This is about the public's trust in the media on critical issues of national security and international relations during one of the most consequential elections of our time. When broadcasters manipulate interviews and distort reality, it undermines democracy itself. The FCC must act swiftly to restore public confidence in our news media. Yep. Well, this is kind of an interesting little situation because, the FCC, which again, brings up the question as to how much power do these regulatory bodies actually have. But in this particular case, with regards to the Federal Communications Commission, I think this is just a matter of making sure that we have a fair and balanced and what is supposed to be an unbiased media for this. So, yeah. Anyway, U.S. Abby Girl said if they thought Trump did something like that, they would have already raised hell. But Trump doesn't have to be edited and staged like the lot lizard Harris. Okay. Well, there's another person who might be in a little bit of trouble. Because there's some new information that has come out. That wonderful blonde lady, she's the daughter of a former vice president who had a little shotgun accident. Yeah. I'm talking about Liz Cheney here. Liz Cheney, who was on the J6 Unselect Committee, as Trump refers to them. Well, according to this article in Just the News, she may have some problems of a legal nature. Liz Cheney contacted controversial January 6th witness on an encrypted app behind the lawyer's back. Messages show. Well, this is interesting. Here in the piece, while Vice Chairwoman of the House Committee investigating the January 6th Capitol riot, former Representative Liz Cheney used an encrypted phone app to directly and indirectly communicate around defense counsel and possibly do it unethically, violating ethical rules, with a witness who would later change her testimony in a shocking fashion, according to evidence obtained by congressional investigators and also obtained by Just the News. So Cheney's signal communications with witness Cassidy Hutchinson on June 6, 2022, and her friend Alyssa Farah Griffin were recently obtained by Representative Barry Loudermilk, who's a Republican from Georgia, chairman of the House Administration Oversight Subcommittee that has identified significant problems with the original Democrat-run inquiry into the January 6th incident. The communications are now raising fresh concerns about the ethical conduct of that particular Democrat-run investigation. Wait, Democrat and ethical in the same sentence? Oh, be still my beating heart. Anyway, back to the piece. At the time of the communication, Hutchinson was represented by attorney Stefan Passantino. Passantino, who told Just the News he did not authorize the contacts with Cheney and was not aware of them until contacted by Just the News. So here's the problem, okay? A third-party lawyer, especially one who is running an investigation into something like this, they're not allowed ethically to contact any of the witnesses or even any of the jurists. I mean, it's the same kind of thing as jury tampering. This could be considered witness tampering. Now, Cheney, it turns out, according to the piece here, Cheney is a licensed lawyer in Washington, D.C., where the D.C. bar rules state unequivocally that, quote, a lawyer shall not communicate or cause another to communicate about the subject of the representation with a person known to be represented by another lawyer in the matter, unless the lawyer has the prior consent of the lawyer representing such other person or is authorized by law or a court order to do so. So in other words, what that means in lawyer speak, let me give you the breakdown here. It basically means that Liz Cheney is not supposed to communicate with somebody who is being represented by another lawyer when you are in a situation or in a trial or a litigation without that other lawyer being present or aware of it. So she may actually end up in a little bit of hot water over this thing. Not saying that anything's probably going to happen, but the fact of the matter is that, as Loudermilk pointed out for Just the News, the communications indicate that Cheney defied her ethical responsibilities and may have influenced a witness outside of her lawyer's presence, eventually causing Hutchinson to switch lawyers. That's a breach of ethical conduct, folks. If you think that Liz Cheney was above board, yeah, I got a bridge in Arizona that's, waterfront property that I can sell you. Loudermilk said, our investigation has uncovered unethical back-channel communications between former Representative Liz Cheney and Cassidy Hutchinson just before Hutchinson changed her sworn testimony. Not only is communicating with a witness without their attorney present unethical, it undermines the integrity of an investigation. So let's see. Let's rack up the things on this January 6th committee. One, they wouldn't let the Secret Service testify as a direct in a direct rebuttal to Cassidy Hutchinson's testimony about Donald Trump reaching for the wheel. So they didn't bother to do that. They didn't even ask. She, meaning Hutchinson, went and changed her testimony afterward, significantly, by the way, changed the record afterwards significantly. And now we have Representative Liz Cheney, who is a lawyer, contacting this particular witness without knowledge of her lawyer. Telling you, these people are just, look, Democrats are like, they're the worst. They just are. There's not an honest one among them that I can tell at this point. And they will do anything that they can in order to win. Now, somebody would look at me and say, well, Liz Cheney was a Republican. Why are you saying that Democrats? No, Liz Cheney is a Democrat. Okay, she's a rhino. She's a complete Republican in name only, especially because she is on the trail, or has been on the trail, campaigning for Kamala Harris. This is ridiculous. She is just a backstabbing rhino, and she's right in line with the Democrats, and she did the Democrats' bidding, and so on and so forth. Between her and Adam Kinzinger, Thank God both of them are out of Congress. But between her and Adam Kinzinger, there wasn't a Republican on that panel at all. So, anyway, 3 Chevy. Liz is as blue as that bird behind you. Wow, I don't know if he meant that to be rhyming, but that was pretty good. That was pretty darn good. 3 Chevy's a very witty guy. Anyway, so anyway, yeah, Liz might be in trouble here, folks. Yeah. Anyway, all right, let's move on here. If you had any question as to whether or not the Democrats, especially the Democrat candidate for president, had any type of respect for those of us who are of a certain religious persuasion, meaning Christians, this should pretty much throw it out the window. Here, in American Greatness. Apparently, she was at one of her rallies, and there was a pro-life heckler there. And the pro-life heckler was being escorted out, and this is at her campaign rally in La Crosse, Wisconsin, on Thursday. So apparently she is, she's having this heckler escorted out, and on the way out, the heckler yells out, "Jesus is Lord." Well, rather than ignoring it, which most of us probably would, or maybe even saying, yes, he is, agreeing with the guy or the gal. The point here, though, is that she responded with this very, very derisive statement. "You guys are at the wrong rally." I thought she was going to be the president for everyone. I thought she was going to be the president for the entire country. That's what she's trying to tell you. But that's not how she acts. She's acting right now as though she is literally scornful, is the best way to put it. Scornful of the Christian religion. So apparently the incident occurred about 20 minutes into Harris's speech, the Milwaukee Journal-Sentinel reported. Right after someone shouted, "Jesus is Lord," Harris is hot back, "Oh, you guys are at the wrong rally." And then the pro-abort crowd, of course, roared with approval. And then she added, "No, I think you're meant to go to the smaller one down the street." Well, we don't know for sure what she was referring to, because Trump apparently drew a massive standing room only crowd at a town hall in La Crosse on August 29. That event, held at the La Crosse Center Arena, drew a crowd of approximately 8,000, while Harris's rally at the La Crosse Recreational Eagle Center that she was at was attended only by approximately 3,000 people, according to the Journal Times. Yeah. So a local woman who attended both events, this is according to, this is in the American Greatness piece, a local woman who attended both events shared her impressions on social media. And she goes, "Notably, I had to show ID to get in to see Kamala Harris." Wait, I thought the Democrats were against identification, especially when voting. They were against it. Well, that's interesting. And then this woman who was the observer also said that the loudest cheers she heard at the rally came in support of abortion. She posted a video on X. "Not a lot of energy here, but everyone just cheered and screamed in support of killing of babies." So that was disappointing. The woman shared the video of Harris scoffing at the pro-lifers and expressed shock that Harris lied about the much larger Trump event. Well, of course she lied. That's all she does. Anyway. The woman pointed out that unlike the Trump event, there weren't long lines of people waiting to get into the Harris campaign's venue, and that there were open spaces. So, just before the heckling began, Harris had said, "Again, we not gonna be gaslighted on this." Yes, I'm not reading that incorrectly. That's how it's written. Yeah, she, yeah, she probably grabbed her affect, one of her accents, to try and appeal or make herself more appealing to a certain crowd. Because remember, she's still trotting out Obama, by the way, to go and woo the black vote that she's been bleeding ever since she essentially announced. But anyway, she apparently prompted lusty boos from the crowd when she said, "We remember Donald Trump hand-selected 3 members of the United States Supreme Court with the intention that they would undo the protections of Roe v. Wade, and they did as he intended." Well, okay, look, you guys, I'm going to tell you, you Democrats out there, first of all, there's hardly any control as to what type of case is going to be presented in front of the Supreme Court. Okay, so I'm trying to understand how they can sit here and say that this was Donald Trump's intent on doing this, that he was able to get 3 people confirmed to the Supreme Court right prior to this case, which was Dobbs, arriving at the Supreme Court. I mean, seriously, the Supreme Court is confirmed by the Senate. So we're talking like a complete perfection of exacting items that would have to fall in perfect alignment with the stars in order to get things to come in. You think that Donald Trump has that kind of power? I don't think he does. I mean, he's good, but he's not that good. Anyway. So yeah, it's just, again, she's just horrible. She is a horrible person. All Democrats are, at least at this point, at least the ones in politics for sure. I mean, I know some Democrats that are nice. They're a little misguided. They're nice people, but they're definitely misguided, and they definitely don't understand the truth. In the words of Ronald Reagan, our liberal friends, it isn't that they're ignorant. It's just that they know so much that isn't so. And this, of course, no truer statement could really be said about the numbers of Democrats that I've run into. So, anyway, hey, real quick, just off the rails kind of thing. Real quick shout out. Hi, Rachel, over on Rumble. She popped in. It's been a while, but thank you for coming. All right. So even Playbook, that whole thing, by the way, just to talk about election interference and that kind of stuff. You remember how I told you last night that they released this, they released the addendum or the appendices of the Jack Smith, Washington, D.C. case. Anyway. Well, Politico has had a comment in there, and I just wanted to point out that Politico, which is Bullshitico, the left-leaning propagandist outlet. But anyway, they took a look at what the appendices had been put out there, and even they are saying that this is the Jack Smith thing gave us nothing. And yes, it is right, Nana. It is the Jack Smith BS case. It's actually Jackass Smith. I forgot to put that in there, Jackass Smith. But anyway, even they are saying that this is just it's a big nothing burger, according to them. So what they say here is that they're talking about the courtroom campaign ends, and they say it's official. Trump has jumped the last major legal hurdle between now and Election Day in his bid to return to the White House. Yesterday, the judge overseeing the criminal case against Trump in Washington over his alleged effort to steal the 2020 election released 4 appendices of evidence compiled by special counsel Jackass Smith and his team of prosecutors at the Justice Department. Now, keep in mind, Jackass Smith is probably not constitutionally appointed. He's more than likely not constitutionally funded either. And so, all of this stuff will go away as soon as that piece gets kind of taken care of. Now, the appeal for Florida, where Judge Eileen Cannon went ahead and put that out, yeah, she basically set the ball in motion, and the appeal hasn't even been heard yet. As far as I know, it hasn't even been scheduled. So, and a real quick question from 3 Chevy says, Rick, can Jackass Smith be fired when Trump gets in? Under the new attorney general? Absolutely, he can. The attorney general could just say, yep, we're done, and close that up. Because again, keep in mind, the Attorney General doesn't have the constitutional authority to make a major or principal office, such as the Office of Special Counsel. That is supposed to be done under Congress. Congress is supposed to make that. And they never did. They, in fact, let the law expire that had it, that congressional approval had. They let it expire in 1999. So anyway, they point out that despite Trump's vigorous objections to the release, and this is the key part, there was not much to pore over, and pretty much nothing in the way of any new revelations. Even the leftist outlet, propagandist outlet, Bullshitico, known as Politico, is even saying clearly that Trump's opponents, and this is a quote, Trump's opponents, Kyle Cheney writes this, Trump's opponents were hoping for more bombshells in Jackass Smith's final document dump before the elections. On Friday, those hopes fizzled. Yeah. No kidding, guys, because there's nothing freaking there. Jackass Smith is just trying to interfere with the elections by announcing these things and hoping that it'll damage Donald Trump's chances. I don't think anybody's really paying attention to it, to be honest with you. I think I covered it way too much longer than what most people even care about at this point. But anyway, they're still going to try. They're going to try. They're going to try. They're going to try. All right. So, one thing that I did want to point out, and this is actually a premium report in the Epic Times. It's a pretty long piece. I put the link in the description of the video. You can go and take a look and listen to it, or read it. I've already gone through and talked about many of these things that is brought up in terms of the legal issues that have been surrounding the 2024 election, such as the Georgia case, the 7 changes thrown out by that one judge, and some of the other cases that are happening around the country right now with regards to the 2024 election and the voter rolls and getting those cleaned up in Virginia and also the Pennsylvania stuff. I've already kind of talked about all of this, so I'm not going to go through it again. But there was one thing at the very end of this piece that I was kind of struck by, and it's all the way down here at the bottom with regards to the U.S. Supreme Court. Now, the U.S. Supreme Court is in its new schedule. God, I can't think of the word. Anyway, they're in their new schedule for their October schedule for their next round. And so the thing about this is that apparently, according to Mike O'Neill, who's the vice president of legal affairs at Landmark Legal, he is saying that the U.S. Supreme Court has left space on its docket in case they have to rehear any cases on an expedited emergency basis. So, what? So apparently, even Ketanji Brown Jackson, who was an activist, not a jurist, by the way, indicated in September that the court was actually anticipating an election-related lawsuit. They're thinking that this could be, oh, thank you, Coco de Whiskey. Yes, their October session. Appreciate that. But they're anticipating something similar to like a Bush v. Gore scenario in 2000. Really? That's interesting. So O'Neill speculated that they have left space there, but he also added that if there is going to be something akin to Bush v. Gore in 2000 and they're going to have to determine equal protection questions or due process questions on an expedited basis, I know the court is prepared to do that. Experts told the Epoch Times the court will likely refrain from taking a case related to this election as well. Adams told the Epoch Times, I think the Supreme Court is highly reluctant to get involved in outcome determinant election litigation. Former Federal Election Commission team member Hans von Sparkowski told told the Epoch Times the possibility of the Supreme Court taking on a case is slim. Kind of interesting that they're talking about this, especially, coming from people who are here in the court system. And he's basically saying that if any lower federal court issues a decision between now and election day that changes any existing rules governing the election process, the only involvement the court would have in any appeal would be to stop that change due to what's called the Purcell Doctrine, which is a court rule that changes should not be made by a federal court shortly before an election, he said. Only if there is a major constitutional conflict after the election is over, the results could I see a case getting to the court, and I think the chances of that occurring is also very slim. Could they be maybe talking about possibly something coming up? In fact, I saw an article that was talking about how close this is, that it's reminiscent of Bush v. Gore, and so on and so forth. I don't know, folks. This is a very contested, very heated, very important election. And hopefully you guys are out there. Those of you that can vote early are already voting and getting your votes in, banking them away. Please do so. All right. Before I get into the main topic for this evening, let me go ahead and tell you about this wonderful patriotic shirtwear clothing line. This shirt that I'm wearing, this is the We the People shirt that I'm wearing right now. We the People, obviously referencing our wonderful Constitution, which it has the words of the Constitution on the shirt itself. It is just fantastic. I'm personally wearing the men's cotton polo version of this shirt, and you can find it at theflagshirt.com. That's right, theflagshirt.com, where they have all kinds of styles for men, women, and children. Plus, if you order $75 or more of their product, they will give you free shipping. But I know people don't have $75 to spend, so I'm going to do what I can to help you out. And that means if you go to flagshirt.americanperspective.online, yes, that's flagshirt.americanperspective.online first, you can grab a coupon code that you can enter in the promo box at checkout at theflagshirt.com and get yourself $5 off your order. Go to flagshirt.americanperspective.online, get yourself that coupon code so that you can enter it in the promo code box at checkout for theflagshirt.com and get $5 off your order. Go to theflagshirt.com and get yourself patriotized. All right. You know as well as I do, if you've been here on the program quite some time, I have made several claims and have kind of backed up those claims that the federal government has grown outside of its constitutional boundaries. Now, for those of you who are on the audio portion of the program, yes, I am holding up the copy of the Constitution, the Saddleback leather-bound U.S. Constitution. And the reason being is because I've read it. Now, I don't know every single section by heart, but that's part of the reason why I have this book, so I can refer to it again and again. The point is, though, folks, that our federal government has outgrown its boundaries, way outgrown its constitutional boundaries. It is beyond what the founders and what our Constitution has stated it actually should be. Now, one of the gentlemen who is a long time study of the Constitution. His name is Paul Engel. Here he is on the back of his book. That's what he looks like. And he is an author of this book called The Constitution Study. And it's the subtitle says, Returning the Constitution to We the People. And one of the things that he does in this book is he goes through and he breaks down the Constitution section by section, article by article, paragraph by paragraph, item by item. And he does an incredibly good job at this. Well, a couple of things struck me before I get into a piece that he actually wrote that triggered this conversation. But one of the things I want to read to you is in the very beginning, a quote by John Jay. And for those of you who are not history buffs, John Jay was the first Chief Justice of the Supreme Court of the United States. And this is what John Jay said or wrote. Every member of the state ought diligently to read and to study the Constitution of his country and teach the rising generations to be free. By knowing their rights, they will sooner perceive when they are violated and be the better prepared to defend and assert them. John Jay is right, folks. And this is part of the reason why I partnered with and became an affiliate with the Institute on the Constitution. We have a lack of understanding, even within our elected leaders right now, of the Constitution and what it's supposed to do, and what each one of their offices are supposed to do. For an example, Joe Biden consistently violates the Constitution by trying to spend or not spend money that hasn't been given to him yet. He does not have the power of the purse. That falls under Congress. Now, all of that, I'd say all of that, I talk all about that. And by the way, you can pick up the Constitution Study. I believe I got this book as a part of the IOTC. I'd have to verify that, but if not, you can find it where booksellers are, booksellers sell stuff. But Paul Engel regularly writes articles and blogs. He does videos and things. He has devoted 20 years of his life, 20 plus years of his life, to educating on both the Bible and the Constitution. And he wrote an article recently that was published as a part of the Institute on the Constitution that talks about the constitutionality of OSHA. That's right, the Occupational Safety and Health Administration. Now, I'm not going to go through the entire article. I encourage you to go and read it. I've got the link in the show description, but I am going to highlight a few certain key areas that he makes the claim, okay, with regards to OSHA in particular in this article, but I am saying that it goes beyond that. OSHA is just one example, one primary example of where the federal government has stepped outside of its constitutional boundaries. So one of the things that he says here in this piece, he points out right in the beginning, setting all this up, he says that when he was researching the book, The Constitution Study, he made a shocking discovery. There are 537 departments and agencies in the federal government, yet only 49 of those agencies exercise powers that are actually delegated to the United States Constitution. One of the cases that he is talking about in specifics is the case All States Refractory Contractors, LLC versus Julie A. Sue, Acting Secretary of Labor, and more, and all. Now, that particular case, okay, and he's got it listed here. He's got links in the piece. They've got links all over the place for this thing. But in this particular case, it's basically asking the question whether or not the establishment of OSHA, whether or not it was constitutional or not. And here is what the case says. Congress gave the Occupational Safety and Health Administration the power to enact and enforce any workplace safety standard it deems, quote, reasonably necessary or appropriate. This petition asks us to consider whether that grant of authority is an unconstitutional delegation of legislative power. Now, keep in mind, OSHA was going to be used by the Biden administration under the idea of workplace safety to force people to take the not vaccine for COVID. Okay. And it was beaten by the Daily Wire, among others. So here's the question that's being asked. Now, unfortunately, just so you know, this petition was actually turned down by the court, which is completely sad. But of course, the defender of freedom and the staunchest conservative on the court, which, by the way, Justice Gorsuch said that he would go ahead and hear the case, and Thomas actually wrote, that's right, the most constitutional and conservative justice on the court, Justice Clarence Thomas, wrote a dissent to deciding to pass on the case. So the law in question, Thomas's dissent, mentions two subsections of Chapter 15 of Title 29 in the U.S. Code, which covers occupational health and safety. And he goes through and starts talking about the two sections. The first one saying that it's defining the occupational safety and health standard, meaning that it's any kind of conditions or the adoption or use of more practices, means, methods, operations, processes reasonably necessary or appropriate to provide a safe and healthful employment and places of employment. And then the second section establishes the procedure for creation and management of the OSHA standards. And it states the secretary may rule, promulgate, modify, or revoke any occupational safety or health standard in the following manner. That the secretary shall publish a proposed rule, promulgating, modifying, revoking, so on and so forth. So basically, the secretary of OSHA can go ahead and just make whatever rules that they decide. Now, for anyone who has watched this program and is attentive to what's happening in the world, we just went through the whole Chevron deference where the court overruled that thought process. And basically, to catch those folks up about the Chevron deference, it was essentially a legally adopted doctrine that essentially stated that when a law is in question about its definition or about its application, you would look to the regulatory agency that was in charge of enforcing it to decide whether or not it was actually enforced or applicable or applied in the correct way. In other words, you look at the cop and you say, hey, this is very bad, but very apropos example. You look at the cop and you say, hey, when you arrested this guy, did you beat him up? And the cop says, well, yeah, I did beat him up. I beat him up because he was fighting me. But yet the guy may not have actually fought while he was, or quote, resisted arrest. But since the cop said that the guy resisted arrest, it's automatically assumed that the guy resisted arrest. And therefore, the deference, or the Chevron deference in this case, would have gone to the police officer. The police officer would have just been deemed automatically correct. Now, granted, that's a very oversimplification, so I don't want to get too far into the weeds on that. But the point here that the thing is making, okay, is the question as to whether or not Congress can actually delegate their authority to regulatory agencies that are in the executive branch. And the question becomes the separation of powers. And here's the reason why. Because in the U.S. Constitution, it basically states that anything regarding legislative authority is invested in Congress. It doesn't say that Congress can therein go and say, well, you know what? Congress decides that they're just going to pass that responsibility off to somebody else. This is one of the arguments that a lot of people have with the creation of the Internal Revenue Service, because the ability to lay and collect taxes resides with Congress, not with the IRS. And so cases of this kind of nature are questioning, and they should be questioning, the constitutionality of whether or not Congress, number one, can just make a generic rule and just say, hey, you know what? We now vest the responsibility of X, whatever that is, into a regulatory body, and we're no longer in charge. Which, again, is a consistent nature. They've been doing this for decades, folks. Decades. Now, one of the arguments that are typically utilized in terms of an argument against such behavior is essentially the point that, well, Congress is basically just, doing this for the general welfare. It falls under general welfare. And one of the things that is, and this in particular is the statement of Article 1, Section 8, Clause 1, which essentially says that Congress shall have the power to lay and collect taxes, duties, imports, excises, to pay the debts, and provide for the common defense and general welfare of the United States. Now, a lot of people try to argue that what's written in the Constitution, what's written in the Constitution can be generally covered by this idea of general welfare. However, we have this thing called the 10th Amendment. And I've been telling you about the 10th Amendment for quite some time. I personally think it's the most underused and potentially the strongest, meaning the most powerful, amendment of the 10. Even though things like the freedom of speech, freedom of the press, that's the first, the Second Amendment, so on and so forth, are all very powerful. But the 10th Amendment, and to some degree the 9th Amendment also, tells you exactly the interpretation that the framers of the Constitution desired. And that is simply this: the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. To put this in other words, it basically says that if the Constitution doesn't specifically state that a power is with the United States government, the federal government, nor if the Constitution doesn't say that it's prohibited to the states specifically, it will always be reserved to the states or the people. Folks, this 10th Amendment is essentially telling you, literally, that the federal government does not have this all-knowing, all-seeing, all-encompassing power. And in fact, Paul writes that Congress is not delegated to the power to regulate labor, Neither is it delegated the power to regulate anything it thinks is for the general welfare. He clearly is saying that the idea, because the general welfare clause within the Constitution was placed in the taxes section, where Congress shall have the power to do X, Y, and Z, lay taxes, lay and collect taxes, that the general welfare clause is tied into the power to lay and collect taxes, imposts, and excises to pay the debts. So in other words, the general welfare is extemporaneously outside of the idea. It's basically just saying, hey, you can apply any taxes, or you can collect any taxes that will provide for you to do your job as defined, which is providing for the common defense and any other ancillary connections that are needed in order to attain that goal. It doesn't mean that the general welfare is a catch-all for everything. And in fact, our wonderful author of the Constitution, James Madison, points this out. He said, as a part of a debate on this bounties for cod fisheries, bounty payments for cod fisheries in February of 1792, he says, and I passed it on the video portion. Hold on. There it is. He says, quote, "If Congress can apply money indefinitely to the general welfare and are the sole and supreme judges of the general welfare, they may take the care of religion into their own hands. They may establish teachers in every state, county, and parish and pay them out of the public treasury. They may take into their own hands the education of children, establishing in a like manner schools throughout the Union. They may assume the provision for the poor. They may undertake the regulation of all roads other than post roads. In short, everything from the highest object of state legislation down to the most minute object of police would be thrown under the power of Congress, for every object I have mentioned would admit the application of money and might be called, if Congress pleased, provisions for the general welfare." So in other words, what James Madison is arguing here is literally that Congress doesn't have the power to just randomly say, oh, well, for OSHA, it's for the general welfare of the public. It's for the general welfare of the United States. Congress doesn't have that power. Paul continues and points out that the General Welfare Clause was never meant as a catch-all power for Congress to do whatever it thought it was, or whatever it thought was for the general welfare of those in the nation. Rather, it seems quite obvious by its placement in the Taxes Clause that the General Welfare Clause was meant to allow Congress to collect taxes to pay for the ancillary costs of its normal duties. Now, Alexander Hamilton stated in Federalist 78, "No legislative act, therefore, contrary to the Constitution can be valid. To deny this would be to affirm that the deputy is greater than his principal, and that the servant is above his master, that the representatives of the people are superior to the people themselves, that men acting by virtue of powers may do not only what their powers do not authorize, but what they forbid." Folks, if it's not clearly written, and I've stated this hundreds of thousands of times, and I'll keep doing it, If it is not stated in Article 1, Section 8 of the Constitution, Congress is not supposed to be passing laws regarding it. Unless there is a constitutional amendment that specifically, and this is done under Article 5 of the Constitution, that specifically hands that power from the states and the people over to the federal government. Congress has grown way outside of its legislative boundaries. By them even remotely considering, and this is part of the reason why I keep saying that healthcare by itself, the ACA, okay, the Affordable Care Act by itself is unconstitutional. There is not one provision in the Constitution of the United States that spells out clearly the responsibility of the federal government is to provide healthcare for everyone. But if you were to challenge somebody on that, they would say it falls within the general welfare. And what I'm saying and what Paul is saying and what even James Madison was saying, that's not the case. The federal government is supposed to be extremely small, very limited in size and scope, and can only do what the Constitution says that it can do, according to the 10th Amendment. This is not a hard concept to understand, but apparently, because of the fact that we as the American people have lacked the education on the proper application of the Constitution, and we have applied things in an emotional manner, we are sitting here looking at, oh, well, you know what? Yeah, it's really good that we go and, help these people out who are having, problems with student loans and debt. And it's good that we use federal money to go ahead and pay that off. Even though student loan debt, even the student loans themselves are not part of the federal government's responsibility in the Constitution. There is nothing that states in the Constitution that the federal government is responsible for any type of education. And this is part of the reason why the Department of Education itself is not constitutional. If you go through and look at all of the departments that we have under the executive branch, they have no business being there. And a lot of them, believe it or not, such as the FBI, as an example, were never established via congressional statute, which is exactly where this whole thing goes. Congress would have to pass a law. That law would have to be involved with the constitutionality of that law. Then that same law would then be passed over to the executive branch. The executive branch would be responsible for implementing and enforcing that particular law. But the question right now that you have, as soon as Congress makes that law, is whether or not it is constitutional for Congress to create a law for something that isn't specifically in the Constitution as a federal responsibility. Now, this goes beyond anything. I'm not even talking about the states, because the states pretty much have their own set of rules and responsibilities. But the federal government cannot just automatically make a law, such as OSHA, such as the FBI, such as all of these other, they can't just automatically make a law if it's not written in the Constitution, specifically under Article 1, Section 8, that is the business of federal government. That's what the 10th Amendment is clearly stating. So, continuing down here further, the whole idea of delegation of those powers, okay, is essentially questionable because the legislative power, all power to make law, is vested solely in the Congress. The Constitution doesn't say, oh, Congress, you can make a law and then that law can then say that you can delegate that power to somebody else. It doesn't say that. What the Constitution does say is that all legislative power is vested in the Congress, made up of two houses, the Senate and the House of Representatives. That's it. Now, for whatever reason, the courts have continually held, which they shouldn't have, but the courts have continually held that that Congress can go ahead and just make a law and it's automatically constitutional. That's not true. And this is part of the argument that a lot of people are making in terms of the IRS. It's Congress's responsibility to lay and collect taxes. I already mentioned that. Now, the court apparently has also made this. Now, this is where it's getting really, really weird because the court has already called this out. Okay, the court has already called this out when it came to a court case. And I'm sorry, I'm losing my head here, but there's a court case with regards to the railroad where the Supreme Court basically said that Congress couldn't pass or delegate its authority to the railroad. So they've already set the precedent that basically says that Congress can't do that. The same thing, very similar thing, that they just ruled in the Chevron deference. They basically kicked it back and essentially said in the response that, hey, you know what? Congress just needs to write better laws to get more exact, more specific on things, rather than leaving it up to a law, up to interpretation by a regulatory body and or the courts. Paul writes here, if, as the court has held, the Constitution categorically forbids Congress to delegate its legislative power to another body, how can they say that delegation of authority is constitutional under any circumstance? The answer is simply by violating their oath of office and placing precedent in politics above the supreme law of the land. So again, we are dealing with a situation here where Congress has usurped its constitutional authority and that nobody has even bothered to try and check it. And therefore, they have allowed our government to grow outside of its constitutional boundaries. Clearly. Now, he points out a little bit further down here about this unconstitutional intelligible principle, which is a test, according to the courts, including the Sixth Circuit Court of Appeals, that they have actually set aside the Constitution in support of a political agenda, namely empowering unelected bureaucrats to effectively make law. This is exactly what's happening. This is where we are at today. In today's situation, this is exactly where we're at. And he continues here, since these unconstitutional laws include the collection of fines, fees, and other pseudo taxes, Congress is in direct dereliction of duty in the very definition of taxation without representation, or as the Declaration of Independence put it, for imposing taxes on us without our consent. There's a lot more to this article that I don't want to cover tonight. I mean, I could go on and on and on about this for several hours. But the point is that we are looking at the most unconstitutional government right here, right now, right today, and that the importance of us getting it back and pushing it back inside its constitutional boundaries, assuming that we can actually even do that, starts with getting rid of the Democrats who don't care about the Constitution, who want to throw it out, who want to step on it and pee on it and rip it up and remake it. We need to vote Republican everywhere you can. We have got to get this country back on track. We have stepped outside, completely outside of the Constitution in today's day and age. And believe it or not, it started back in like the 40s and 50s. It actually even started, I digress, it actually even started further back than that, back under the Great Depression, which was extended by about 12 years, according to many scholars, because of the policies that were put in place by the federal government. All right, so let's get on to the question of the week, because, yeah, this one's a doozy. This one's a doozy. So here we go. Question of the week. All right. So tonight's question of the week comes in from, of course, the venerable, the smart, the intelligent, the ancient wise one, Buddy Weiser. Buddy writes this. Good day, my internet acquaintance. I hope my message finds you well and with friendly skies ahead. Well, unfortunately, it's kind of raining and windy, so anyway, moving on. My question is, would you please define the Alien Sedition Act 1798 and how it may possibly be used in current situations? Thanks, Buddy Weiser. He also writes, and I'm only bringing this up because I actually talked to her, but he also writes, P.S. Ask your wife to make an appearance on the program from time to time. I'm sure all the warriors would agree and enjoy her comments. Well, believe it or not, I'm going to answer that question first. So I asked Mrs. Whiskey if she would be willing to come on the program from time to time, and she actually did say yes. So we will schedule a time or try and get together with the time where we could bring her in, Mrs. Whiskey, in on some of this discussion. So anyway, and we'll figure out the appropriate an appropriate topic and so on and so forth. All right, so let's get down to the Alien Sedition Act of 1798. Now, the way you wrote it made it sound like it was just one act. It actually isn't. 1798, just to kind of put it all sort of in a historical context, 1798 was shortly after the Constitution was actually formed and signed and so on and so forth. And it was happening during, this in particular was happening during an anticipated, excuse me, an anticipated expected war with France. So there was a thing called the XYZ affair, in which war with France had appeared that it was going to be inevitable. And the Federalists, which were a political party, by the way, were in control, and they were aware of the fact that many of the French military successes in Europe had actually been facilitated in a very positive way for the French by political dissidents in the invaded countries. And since we were preparing for, or thinking that we were going to be going to war with France, one of the things that the Federalists did, because they were both in control of the presidency as well as the Congress at the time, they adopted what is called the Alien and Sedition Acts as part of a series of essentially military preparedness measures. Now, the three alien laws that were passed during June and July of that year were aimed at French and Irish immigrants specifically, who were, at the time, mostly pro-French. And these laws actually took the waiting period for naturalization from what was 5 years, or decided upon originally as 5 years, up to 14 years. those same acts also permitted the detention of subjects of an enemy nation. So in other words, if somebody from France had come across, or in this particular case, Ireland, had come across and like came into our country, it permitted us as Americans to go and detain those people who came here. It also authorized the chief executive, meaning the president, to expel any alien that he considered dangerous. Now, along with that was the Sedition Act, which was passed in July 14th. And that one actually banned the publishing of false or malicious writings against the government, and also was set up to prevent inciting opposition from any act of Congress or the president. Now, practices of that nature were already kind of forbidden in some state or some cases by state libel law statutes and common law by itself. But it wasn't up until that point stopped by federal law. Okay. The Federal Act actually reduced the oppressiveness of procedures in prosecuting such offenses, but provided for the federal enforcement. Okay. Now, these acts, these 4 acts, were relatively mild compared to some of the later security measures that were put together in the United States. And many people thought that they were popular. They liked that idea, sort of like the Patriot Act was after 9/11. You know, everybody was like on board with the Patriot Act. Oh yeah, we got to do this, without even thinking about what it was going to do and what kind of an impact it was going to have on our rights. Okay. So Jefferson Republicans, or Jeffersonian Republicans, okay, they were against them. They were against the Federalists in this. And they basically were like, okay, look, you guys can't do this. This isn't, you know, and they vehemently opposed them. What ended up happening is that none of the aliens actually, or no aliens were actually deported, but there were 25 prosecutions on the federal level, resulting in 10 convictions under the Sedition Act. And as the war threat passed, okay, Republicans ended up winning control of the federal government in 1800. And so what ended up happening is these 4 acts were summarily repealed. They're actually not even in existence anymore, basically. Okay. They also, and some of them, by the way, some were repealed, some were expired. I need to correct that statement. And essentially these were kind of the early U.S. naturalization laws that of course Congress was provided by the Constitution. Congress was supposed to be in charge of this. Now, all of that being said, okay, the Naturalization Act of 1790 provided that any free white person who resided within the limits and under the jurisdiction of the United States for at least 2 years could be granted citizenship if he or she showed good character and swore allegiance to the Constitution. It was later, of course, increased to 5. So that's kind of basically sort of where it came from. By 1795, Congress had amended the naturalization law by requiring an applicant to submit a declaration of intent to become a citizen at least 3 years before naturalization. And extended the minimum residency to 5 years. So that's where the residency came in. Okay. So those, I think I didn't really look up the most recent laws, but basically over the course of many, many years, Congress has continued to establish naturalization policies with varying conditions, restrictions. Despite these differences, naturalization laws, uniformly require that an applicant prove residence in the United States for a specific time period prior to acquiring citizenship. So they all kind of require you to have lived here for a certain amount of time. The thing about it is, though, of course, that, so in 1802, Congress, which was the Republican Congress, the Jeffersonian Republican Congress, repealed the previous laws, which were the Alien and Sedition Acts, and restored both the 5-year residence requirement and the 3-year declaration of intent period. So, I don't know I don't know where they are now. I didn't look that up, but, basically they, essentially they kind of took them out. So how are they possibly used in today's current situations? They can't be, because again, they were repealed. So realistically, it would be based off of probably the Immigration and Naturalization Act, which is currently under effect. And so, and by the way, the INA does allow for the president to essentially shut the border at any time for any length of time for any class of person trying to cross. And it also does state that if you cross here illegally, you are to be deported. So all of this is going to be legal. Everything that Donald Trump is talking about, deporting all of these illegal aliens, it's all within already approved law and signed law in congressional statutes. So it's all there. But anyway, it kind of gives you an idea, reminiscent, given the fact that it was targeted at not only at the French and the Irish, but they also, some historians are looking at this and saying that it was targeted at the Jeffersonian Republicans as well, that there was a political kind of thing as at the same time, because the Federalists, they didn't get along with the Republicans of the time back there, the Jeffersonian Republicans. So anyway. All right. Hopefully that answered your question. And of course, if you have a question for me to submission for question of the week, you can submit it to my email address, fans@americanperspective.online. That's fans@americanperspective.online. And just put in the subject line, question of the week, and we'll go ahead and get things going. Same thing goes with Pet of the Week that happens on Wednesday. For those of you who may not be, this might be your first time on the program, you might not be familiar, but Wednesday night I have a segment called Pet of the Week where I highlight a listener's pet. And you can send me pictures and stories and things like that also to fans@americanperspective.online. Well, thank you all, everybody, for joining. I know I'm a little bit over time. I do appreciate it. Do me a favor, if you haven't already, head on over to rumble.com, get yourself an account. It's free. And once there, sign up or sign in. And once you are signed in, search up the American Perspective channel. Make sure you hit that green follow button to know when I go live every single time. It'll notify you every single time. Also, too, don't forget, before you take off, hit all of those thumbs up, like buttons across all of my platforms, whether it's Twitter, Facebook, YouTube, and Rumble, all as well. We will see you Monday at 5 p.m. That's an hour earlier than Saturday's show. 5 p.m. Pacific, 8 p.m. Eastern time, right here on American Perspective. Have a great rest of your weekend, and we will see you all on Monday. Good night, everybody.
The previous broadcast was produced and is owned by Active Eye Media LLC. All rights reserved.